If principles, the following principles would ordinarily guide a court in determining the amount of mercenary profits. First, no profit by a person in wrongful possession. Second, restoration of status being before disposition of a decree holder. And third, use to which a decree holder would have put the property if he himself was in possession. G. Illustration. Thus, in a suit for title and possession where the land is in the occupation of a tenant, mercenary profit should be awarded on the basis of rent and not on the basis of produce or value of property. At the same time, however, mercenary profits cannot be calculated on the basis of a standard rent or maximum rent that a landlord could have received if premises were let out afresh. Though the amount of standard rent is a relevant factor for calculating mercenary profits, it is not decisive. But when a person in wrongful possession plants indigo on the land and it is proved that a prudent agriculturist would have planted sugarcane, wheat, or tobacco, the mercenary profits should be assessed on the basis of those more profitable crops. H is interest. Since interest is an integral part of mercenary profits, it has to be allowed in the computation of mercenary profit itself. The rate of interest is at the discretion of the court, subject to the limitation that the said rate shall not exceed 6% annum. Such interest can be allowed till the date of payment. I deductions. While awarding mercenary profit, the court may allow deduction to be made from the gross profit of the defendant in wrongful possession of the property, such as land, revenue, rent, cesses, cost of cultivation and reaping, the charges incurred for collection of rent, etc. In other words, mercenary profit should be net profits. 11 is public officer. Public officer means a person falling under any of the description in section 2, subsection 17 of the code. Thus, every judge, every member of all India service, every gazetted officer of union, every officer of court of justice or of government, a minister of a state, a receiver, a village headman, an officer in the Indian Army, a sheriff of Bombay, a bench clerk of a civil court, an inspector of police, a custodian of evacuee property, provident fund commissioner, an advocate engaged by the government on day fees, and income tax officer, etc. are public officers. But a retired government servant, a port commissioner, a liquidator under the Cooperative Society Act, a chairman of a municipality, a municipal councillor, an officer of a corporation, etc., not public officer. Other important terms. There are certain other terms, though they are important, they have not been defined in the code. It has been rightly said that where a word is not defined in a statute, it is permissible to refer dictionaries to find out sense in which it is understood. In common parlance, let us consider some important terms not defined in the code. Do you want to know the time? What time is it? It's already midnight and it's 1:30, which makes it 1:30 a.m. If you are not believing, then you can see the watch. If is it visible, so you can just take a SS and just do the mirroring thing of that SS, and then you will see it's 1:30. I was not feeling sleepy, so I thought, what should I do? Then I decided, then at least I can read, I can complete my target, so that the burden will be less for tomorrow. That's it. Other important terms. There are certain other important. There are. We have already read this paragraph, but still I can repeat it. There are certain other terms, though they are important, they have not been defined in the code. It has been rightly said that where a word is not defined in a statute, it is permissible to refer dictionaries to find out sense in which it is understood in common parlance. Let us consider some important terms that are mentioned in CPC which we will see in definition in section 2. So let us consider some important terms not defined in the code. First one is affidavit. An affidavit is a declaration of facts. What is an affidavit? An affidavit is a declaration of fact reduced to writing and affirmed or sworn before an officer having authority to administer oaths. It should be drawn up in the first person and contain a statement and not inferences. What what is the meaning of inferences? Can I check it? Should I? I must. I should. Inferences. What does it mean? Anuman. Okay, got it. Second one is appeal. The expression appeal may be defined as the judicial examination of the decision by a high court of the decision of an inferior court. The expression appeal may be defined as the judicial examination of the decision by a higher court of the decision of an inferior court. It is a complaint made to a higher court that the decree passed by lower court is wrong. It is a remedy provided by law for getting the degree of a lower court set aside. The right of appeal is a creature of a statute, and unless it is granted clearly and expressly, it cannot be claimed by a person. Again, it is a vested right and can be taken away only by a statutory provision, either expressly or by necessary implication. What is point number 3? Cause of action. What is cause of action? Cause of action may be described as a bundle of essential facts which it is necessary for the plaintiff to prove before he can succeed. A cause of action is the foundation of the suit. Foundation of a suit. It must be antecedent. What is antecedent? Antecedent. Antecedent. पूर्वपद, पूर्वगामी, पूर्व इतिहास. It must be antecedent to the institution of a suit, and on the basis of it, the suit must have been filed. If a plaintiff does not disclose a cause of action, a court will reject such plaint. Okay, so be aware. If your suit doesn't contain any cause of action, that it can be, or it will be, or it shall be disposed of, or the court can reject that plaint. Point number 4, caveat. According to its dictionary meaning, a caveat is an official request that a court should not take a particular action without issuing notice to the party lodging the caveat and without affording an opportunity of hearing him. Point number 5, civil. The word civil pertains to right and remedy of a citizen as distinguished from criminal, political, etc. The expression civil proceedings covers all proceeding in which a party asserts civil rights conferred by a civil law. Point number 6, court. Court is a place where justice is administered. To be a court, the person constituting it must have been entrusted with judicial function. The term court in CPC refers to civil courts. Next, point number 7, defendant. Defendant means a person who defends or a person sued in a court of law by a plaintiff. In every suit, there must be two parties, namely the plaintiff and the defendant. A defendant is a person against whom a relief is claimed by a plaintiff. Next, point number 8, execution. Stated simply, execution means the process of enforcing or giving effect to the judgment, decree, or order of a court. Point number 9, issue. According to concise Oxford Dictionary, issue means a point in question, an important subject of debate or litigation. So if we will analyze the Oxford Dictionary, then in that we will find that issue means a point in question. A point in question. What's the issue? Means we are asking what is that point that is in question. Okay. A point in question, an important subject of debate or litigation. Issues are of three kinds: issue of fact, issue of law, and mixed issue of fact as well as law. That makes mixed issue of fact and law. Issue arises when a material proposition of fact or law is affirmed by one party and denied by the other. Point number 10, jurisdiction. Stated simply, jurisdiction means authority to decide. Jurisdiction may be defined to be the power or authority of a court to hear and determine a cause, to adjudicate and exercise any judicial power in relation to it. Jurisdiction means the extent of the authority of a court to administer justice prescribed with reference to subject matter, pecuniary value, and territorial limits. Consent can neither confer nor take away jurisdiction of a court. Next, point number 11, plaint. A plaint is a statement of claim, a document, or a memorial by the presentation of which a suit is instituted. It contains the ground on which the assistance of a court is sought by a plaintiff. It is a pleading of the plaintiff. It is a pleading of the plaintiff. It is a pleading of the plaintiff, and that is called plaint. So, pleading of a plaintiff is plaint. Okay. Next is plaintiff. Plaintiff is a person who brings a suit or commences an action against a defendant. It is the plaintiff who approaches a court of law by filing a suit for relief claimed in the plaint. What is suit? A word suit ordinarily means a civil proceeding instituted by the presentation of a plaint. In its comprehensive sense, the word suit is understood to apply to any proceeding in a court of justice by which an individual pursues that remedy which the law permits. A summons is a bit point number 14. Summons is a summons. Sorry for the pronunciation. It is summons. So point number 14 is summons. Point number 14 talks about summons. A summons is a document issued from an office of a court of justice calling upon the person to whom it is directed to attend before a judge or an officer of a court for a certain purpose. It is a written order that legally obligates someone to attend a court of law at a specific date. When a plaintiff files a suit, the defendant must be informed about it. The intimation which is sent to the defendant by the court is technically known as summons. So, the intimation which is sent to the defendant by the court is technically known as summons. A summons can also be issued to witnesses. Service of summons can be effected in any of the modes recognized by the court. Any of the mode means via email, via post, and via police officer, via through the plaintiff. So it can be with any mode. Okay. Next, point number 15 is written statement. Written statement may be defined as a reply of a defendant to the plaintiff filed by a plaintiff. Thus, it is a pleading of a defendant dealing with every material fact of a plaint. It may also contain new facts in favor of defendant or legal objection against the claim of a plaintiff. It is a pleading of a defendant. It is a pleading of a defendant. And with this, we have just completed the part 1. So, should I stop it here? Should I pause the video here? And part 1, in part 1. Okay, this chapter has been finished. We will start from part 2, and in part 2 there is a chapter 1, so we will read it from there. I can read it right now, but I thought maybe I should upload the video in portion, in parts. I have no issues. I can continue from here also. But before that, I will have a sip of water. I said that I will take a sip, but I just started gulping up the water. Gulping up. You mean gulping up? Ghutak ghutak ke peena. So let's start. We are going to start. Sorry, I am going to start part 2, in which I am going to read chapter 1. Jurisdiction of civil courts. Jurisdiction of civil courts. General. The fundamental principle of English law that wherever there is a right, there is a remedy. Okay, and in Latin term, we call it ubi jus ibi remedium. Wherever there is a right, there is a remedy. Ubi jus ibi remedium. Ubi jus ibi remedium. Ubi jus ibi remedium. Wherever there is a right, there is a remedy. Ubi jus ibi remedium has been adopted by the Indian legal system also. In fact, right and remedy are but the two sides of the same coin, and they cannot be separated from each other. Accordingly, a litigant having a grievance of a civil nature has a right to institute a civil suit in a competent civil court unless its cognizance is expressly or either impliedly barred by any statute. A suit for its maintainability requires no authority of law, and it is enough that no statute bars it. Jurisdiction meaning the term jurisdiction has not been defined in the code. The term jurisdiction has not been defined in the code. The word jurisdiction is derived from the Latin term juris and dicto which means I speak by the law. I speak by the law. Stated simply, jurisdiction means the power or authority of a court of law to hear and determine a cause or a matter. It is the power to entertain, deal with, and decide a suit, an action, a petition, or other proceeding. In other words, by jurisdiction is meant the authority which a court has to decide matters that are litigated before it or to take cognizance of matters presented in a formal way for its decision. Thus, jurisdiction of a court means the extent of the authority of a court to administer justice prescribed with the reference to the subject matter, pecuniary value, and local limits. In official trustee versus Sachindranath, after this is a case name, official trustee versus Sachindranath. After referring to various decisions, the Supreme Court observed from the above discussion, it is clear that before a court can be held to have jurisdiction to decide a particular matter, it must not only have jurisdiction to try the suit brought, but must also have the authority to pass the orders sought for. It is not sufficient that it has some jurisdiction in relation to the subject matter of the suit. Its jurisdiction must include the power to hear and decide the question at issue, the authority to hear and decide the particular controversy that has arisen between the parties. Point number 3, jurisdiction and consent. It is well settled that consent cannot confer nor take away jurisdiction of a court. In the leading case of A.R. Antule versus R.S. Nayak Mukherjee, Justice, as he was then stated, the court, by its direction, could not confer jurisdiction on the High Court of Bombay to try any case for which it did not possess. It was further stated the power to create or enlarge jurisdiction is legislative in character, so also the power to confer a right of appeal or to take away right of appeal. Parliament alone can do it by law, and no court, wherever superior or inferior or both combined, can enlarge the jurisdiction of a court or divest a person of his rights of revision and repeal. If the court has no inherent jurisdiction, neither acquiescence nor waiver nor estoppel can create it. A defect of jurisdiction goes to the root of the matter and strikes at the authority of a court to pass a decree. Such a basic and fundamental defect cannot be cured by consent of parties and the judgment or order passed by a court, however precisely certain and technically correct, is null and void, and the validity thereof can be challenged at any stage. A decree passed without jurisdiction is non-est. What does mean non-est? Anidharit, and its validity can be set up whenever it is sought to be enforced as a foundation for a right, even at the stage of execution or in collateral proceeding. In short, a decree passed by a court without jurisdiction is a quorum non judice. What is the meaning of quorum non judice? Before one who is not a judge. Before one who is not a judge. So, you can't file a suit in that court who do not have jurisdiction to deal that particular suit. And if you are presenting that suit in front of that court, that gonna be mean that court is quorum non judice, means the suit has been presented in front of the person before one who is a person before one. The suit has been presented before one who is not a judge. Quorum non judice. And what was that Latin term, Latin phrase? Ubi just ibi remedium. Wherever there is a right, there is a remedy. And what is this? Quorum non judice. Quorum non judice. Quorum non judice. Before one who is not a judge. Quorum non judice before one who is not a judge. As simple as that. We have completed till page number 41. We started from page number 32 and page number 31 to 32, in between page number 31 to 32, and we have successfully read up till page we have successfully read 10 pages. In the case of Kiran Singh versus Chaman Paswan, the Supreme Court observed, it is a fundamental principle well established that a decree passed by a court without jurisdiction is a nullity, and that its invalidity could be set up whenever and wherever it is sought to be enforced or relied upon. Even at the stage of execution and even in collateral proceeding, a defect of jurisdiction strikes at the very authority of the court to pass any decree, and such a defect cannot be cured even by consent of parties. Conversely, what does the meaning of conversely? Iske viprit. What does the meaning of conversely? Iske viprit. Conversely, where a court has jurisdiction, where a court has jurisdiction to decide a dispute, the same cannot be taken away or ousted. Ousted means bedakhal by consent of parties. An agreement to oust absolutely the jurisdiction of the court would be unlawful and void, being against public policy ex dolo malo non oritur exio. 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 What does it mean? No action arises from fraud. No action arises from fraud. Ex dolo malo non oritur exio. Ex dolo malo non oritur exio. No action arises from fraud. Okay, fine. But if two or more courts have jurisdiction to try the suit, it is open to the parties to select a particular forum and exclude the other forums, and therefore the parties may agree among themselves that the suit should be brought in one of those courts and not in other. Since there is no inherent lack of jurisdiction in the court, such an agreement would be legal, valid, and enforceable. Point number 4: lack of jurisdiction and irregular exercise of jurisdiction. Lack of jurisdiction and irregular exercise of jurisdiction. There is always a distinction between want of jurisdiction and irregular exercise of it. Once it has held that a court has jurisdiction to entertain and decide a matter, the correctness of the decision given cannot be said to be without jurisdiction, in as much as the power to decide necessarily carries with it the power to decide wrongly as well as rightly. In the word of Lord Hobhouse, a court has jurisdiction to decide wrong as well as right. If it decides wrong, the wrong party can only take the course prescribed by law for setting matters right, and if that course is not taken, the decision, however wrong, cannot be disturbed. In other words, if there is inherent lack of jurisdiction, the decree passed by a civil court is a nullity, and that nullity can be set up in any collateral proceedings. However, if a court has jurisdiction but it is irregularly exercised, the defect does not go to the root of the matter, and the error, if any, in exercising the jurisdiction can be remedied in appeal or revision, and when there is no such remedy or is not avail of, the decision is final. In Ityavira Mathai versus Varke, it was contended that the decree passed by the court was a nullity since the suit was time barred. Negativing that contention, the Supreme Court observed, if the suit was barred by the time and yet the court decreed it, the court would be committing an illegality, and therefore the aggrieved party would be entitled to have the decree set aside by preferring an appeal against it. But it is well settled that a court having jurisdiction over the subject matter of the suit and over parties thereto, though bound to decide right, may decide wrong, and that even though it decided wrong, it would not be doing something which it had no jurisdiction to do. If the party aggrieved does not take appropriate steps to have that error corrected, the error in the erroneous decree will hold good and will not be open to challenge on the basis of being a nullity. The difficult question, however, is what is the distinction between absence of jurisdiction and erroneous or irregular exercise thereof? After the landmark decision in Annie Minnick Limited versus Foreign Compensation Commission, the legal position is considerably changed. It virtually it virtually assimilated the distinction between lack of jurisdiction and erroneous exercise thereof. As observed in ML Sethi versus RP Kapoor, the difference between jurisdictional error and error of law within jurisdiction has been reduced almost to a vanishing point. The following observation, pitli means matlab ki baat, but the legal position thus कुछ इस प्रकार Annis Minnick after Annis Minnick, every error of law is a jurisdictional error. The distinction between jurisdictional and non-jurisdictional error is ultimately based upon a foundation of sand. Much of the superstructure has already crumbled. What remains is likely quickly to fall away, as the courts rightly insist that all administrative actions should be simply lawful, whether or not jurisdictionally lawful. Point number 5, basis to determine jurisdiction. It is well settled that for deciding the jurisdiction of a civil court, the averments made in the plaint are material. To put it differently, the jurisdiction of a court should normally be decided on the basis of the case put forward by the plaintiff in his plaint and not by the defendant in his written statement. Thus, in Abdullah bin Ali versus Galappa, the plaintiff filed a suit in the civil court for declaration of title and for possession and mesne profits, treating the defendants as trespassers. The defendants contended that the civil court had no jurisdiction since he was a tenant. Negativing the contention of the defendants, the Supreme Court observed there is no denying the fact that the allegation made in plaint decide the form. The jurisdiction does not depend upon the defense taken by the defendants in the written statement. On a reading of the plaint as a whole, it is evident that the plaintiff appellants had filed the suit giving rise to the present appeal, treating the defendants as trespassers as they denied the title of the plaintiff appellants. Now a suit against the trespasser would lie only in the civil court and not in the revenue court. We are therefore of the considered opinion that on the allegation made in the plaint, the suit was cognizable by the civil court. The plaintiff, however, cannot, by drafting his plaint, cleverly circumvent the provision of law in order to invest jurisdiction in civil court, which it does not possess. It is also well established that in deciding the question of jurisdiction, what is important is the substance of the matter and not the form. Thus, in Bank of Baroda versus Moti Bhai, the plaintiff bank lent a certain amount to the defendant in the usual course of its commercial business by way of a collateral security. However, it obtained a hypothecation bond and a deed of mortgage from the defendant under the Tenancy Act, conferring exclusion jurisdiction on the revenue court. When the suit was filed in the civil court for a recovery of amount, it was contended by the defendant that the civil court had no jurisdiction to try the suit. Negativing the contention, the Supreme Court observed that business of the bank was to lend money if only by way of collateral security. The bank obtained a hypothecation bond or a deed of mortgage. The provision of the Tenancy Act cannot be attracted. Primarily and basically, The suit filed by the bank was for the recovery of the amount due to it by the defendant on the basis of the promissory note executed by the defendant. The main relief sought by the bank was that the suit should be decreed for repayment of amount. The civil court had therefore jurisdiction to entertain the suit filed by the bank. On the question of the jurisdiction, one must always have regard to the substance of the matter and not to the form of the suit. Again, when a court of limited jurisdiction, rent controller, has jurisdiction to decide only a particular dispute, fixation of standard rent, it has jurisdiction to consider the collateral issue, title of the landlord to property only prima facie, and the jurisdiction of a civil court to decide such issue finally is not taken away. It is submitted that the following observation of the full bench of the Allahabad High Court in Ananti vs. Shanu and approved by the Supreme Court lay down the correct law on the point. The plaintiff chooses his form and files his suit. If he establishes the correctness of his facts, he will get his relief from the forum chosen. If he frames his suit in a manner not warranted by the fact and goes for his relief to a court which cannot grant him relief on the true facts, he will have his suit dismissed. Then there will be no question of returning the plaint for presentation to the proper court, for the plaint as framed would not justify the other kind of court to grant him the relief if it is found on a trial on the merits. So far as this issue of jurisdiction goes, that the facts alleged by the plaintiff are not true and the facts alleged by the defendant are true, and that the case is not cognizable by the court, there will be two kinds of orders to be passed. If the jurisdiction is only one relating to territorial limits or pecuniary limits, the plaintiff will be ordered to be returned for presentation to the proper court. If, on the other hand, it is found that having regard to the nature of the suit, it is not cognizable by the class of court to which the court belongs, the plaintiff's suit will have to be dismissed in its entirety. I have already read till page number 46. Now I am thinking I am in dilemma, like whether I should read up till page number 50 or should I pause the video here only. Kind of a very small dilemma. I also have to prepare the notes of Limitation Act, but I'm thinking I should touch up the I should pick up the Limitation Act, or should I what should I do? How many pages are there in CRPC, that is Bharatiya Nagrik Suraksha Sanhita 2023? As I can see, it contains almost 250 pages with 531 sections. So 50 pages of this and 20 pages of this. It will work. Will it work? 20 pages means 10 days. Makes sense. CPC as well as CRPC. Tomorrow, tomorrow I have to read 50 pages. 50 pages of CPC of, of this video only, like this topic only. Um, the book right now I'm reading, that is commentary book. So I have to read the next 50 pages. Let's try to read one or two more pages. Heading number 6, jurisdictional fact. The jurisdiction of a court, tribunal, or authority may depend upon fulfillment of certain conditions or upon existence of a particular fact. This is called jurisdictional fact. The existence of such a preliminary or collateral fact is a sine qua non or a condition precedent to the assumption of jurisdiction by the authority. If it exists, the authority has jurisdiction and it can act. If it does not exist, there is no jurisdiction and the authority cannot act. If the authority wrongly assumes existence of such fact, a writ of certiorari can be issued. Topic number 7, decision as to jurisdiction. Whether a court has jurisdiction or not has to be decided with reference to the initial assumption of jurisdiction by that court. The question depends not on the truth or falsehood of the facts into which it has to inquire or upon the correctness of its finding on these facts, but upon their nature and it is determinable at the commencement, not at the conclusion of the inquiry. Whenever the jurisdiction of a court is challenged, the court has inherent jurisdiction to decide the said question. Every court or tribunal is not only entitled but bound to determine whether the matter in which it is asked to exercise its jurisdiction comes within its jurisdiction or not. Similarly, where a tribunal derives its jurisdiction from the statute that creates it and imposes condition under which it can function, it goes without saying that before the tribunal assumes jurisdiction in a matter, and it must be satisfied that those conditions in fact exist. Such facts are known as preliminary or jurisdictional facts. Now, point number 8 is courts and tribunals. A civil court has inherent power to decide the question whether it has jurisdiction to entertain, deal with, and decide the matter which has come before it. The jurisdiction of a tribunal or any other authority stands on a different footing, where Parliament has invested such tribunal with the power to decide and determine finally the preliminary facts on which its jurisdiction depends. It can decide such facts, and the finding recorded by the tribunal cannot be challenged by certiorari. But whereas statute creating or establishing a tribunal does not confer the power on a tribunal, an inferior tribunal cannot, on a wrong decision on preliminary or collateral fact, assume and confer on itself jurisdiction which it does not which it does not possess. Such an order can be challenged by certiorari. Point number 9, jurisdiction of foreign courts. Point number 10, kind of jurisdiction. Jurisdiction of a court may be classified under the following categories. First, civil and criminal jurisdiction. Civil jurisdiction is that which concern and deals with dispute of a civil nature, and criminal jurisdiction, on the other hand, relates to crimes and punishes offenders. Point number second, territorial and second type is territorial and local jurisdiction. Every court has its own local or territorial limits beyond which it cannot exercise its jurisdiction. These limits are fixed by the government. The district judge has to exercise jurisdiction within his district and not outside it. The High Court has jurisdiction over the territory of a state within which it is situate and not beyond it. Again, a court has no jurisdiction to try a suit for immovable property situated beyond its local limits. Point number 3, pecuniary jurisdiction. The court provides that a court will have jurisdiction only over those suits the amount or value of the subject matter of which does not exceed pecuniary limit of its jurisdiction. Some courts have unlimited pecuniary jurisdiction. For example, high courts and district courts have no pecuniary limits, but there are other courts having jurisdiction to try suits up to a particular amount. Thus, a presidency small causes court cannot entertain a suit in which the amount claimed exceeds rupees 1000. Point number 4, jurisdiction as to subject matter. Different courts have been empowered to decide different types of suits. Certain courts are precluded from entertaining certain suits. Thus, a presidency small causes court has no jurisdiction to try suits for a specific performance of a contract, partition of immovable property, foreclosure or redemption of a mortgage, etc. Similarly, in respect of testamentary matters, divorce cases, probate proceeding, insolvency proceeding, etc., only the district judge or civil judge, that is senior division, has jurisdiction. Point number 5, original and appellate jurisdiction. Original jurisdiction is jurisdiction inherent in or conferred upon a court of first instance. In the exercise of that jurisdiction, a court of first instance decides suits, petition or application. Appellate jurisdiction is a power or authority conferred upon a superior court to rehear by way of appeal, revision, etc. of causes which have been tried and decided by courts of original jurisdiction. Next is municipal courts of civil judges. Small cause courts are having original jurisdiction only, while district courts, high courts have original as well as appellate jurisdiction. Point number 6, exclusion and concurrent jurisdiction. Exclusive and concurrent jurisdiction. Exclusive jurisdiction is that which confers sole power on one court or tribunal to try, deal with, and decide a case. No other court or authority can render a judgment or give a decision in the case or class of cases. Concurrent or coordinate jurisdiction is jurisdiction which may be exercised by different courts or authorities between the same parties at the same time and over the same subject matter. It is therefore open to a litigant to evoke jurisdiction of any of such court or authority. Point number 7, general and special jurisdiction. General jurisdiction extends to all cases comprised within a class or classes of causes. Special or limited jurisdiction, on the other hand, is jurisdiction which is conferred to special, particular, and limited causes. Point number 8, legal and equitable jurisdiction. Legal jurisdiction is a jurisdiction exercised by common law courts in England, while equitable jurisdiction is a jurisdiction exercised by equity courts. Courts in India are courts of both law and equity. Point number 9, municipal and foreign jurisdiction. Municipal or domestic jurisdiction is a jurisdiction exercised by municipal courts. For example, that is court in a country. Okay. Municipal or domestic jurisdiction is a jurisdiction exercised by municipal courts, that is court in country. Foreign jurisdiction means jurisdiction exercised by a court in a foreign country. A judgment rendered or decision given by a foreign court is a foreign judgment. Point number 10, expounding and expanding jurisdiction. Expounding jurisdiction means to define, clarify, and explain jurisdiction. Expanding jurisdiction means to expand, enlarge, or extend the jurisdiction. It is the duty of the court to expound its jurisdiction. It is, however, not proper for the court to expand its jurisdiction. Now, point number 11, jurisdiction of civil courts. Point number 1, section 9. Under the Code of Civil Procedure, a civil court has jurisdiction to try all suits of a civil nature unless they are barred. Section 9 of the code reads as under: the court shall, subject to the provision herein contained, have jurisdiction to try all suits of a civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. Explanation first. A suit in which the right to property or to an office is contested is a suit of a civil nature, notwithstanding that such right may depend entirely on the decision of question as to religious rites or ceremonies. Explanation 2. For the purposes of this section, it is immaterial whether or not any fees are attached to the office rendered to in explanation 1, or whether or not such office is attached to a particular place. For the purpose of this section, it is immaterial whether or not any fees are attached to the office rendered to in explanation 1 first, ये तो यहाँ तक आया, or whether or not such office is attached to a particular place. Okay. Point number 2, conditions. A civil court has jurisdiction to try a suit if two conditions are fulfilled. First, the suit must be of a civil nature, okay, and second, the cognizance of such a suit should not have been expressly or impliedly barred. Okay, we are on page number 50 and now it's getting very boring for me, but still I have to at least read this page. It will take 3 hours to read 50 pages tomorrow. Then I have to read that. I can pick BNS or it will be BNSS. Okay, let's complete it. First, a suit of civil nature, meaning in order that a civil court may have jurisdiction to try a suit, the first condition which must be satisfied is that the suit must be of a civil nature. But what is a suit of a civil nature? The word civil has not been defined in the code, but according to the dictionary meaning, it pertains to private rights and remedies of a citizen as distinguished from criminal, political, etc. The word nature has been defined as the fundamental qualities of a person or thing. Identity or essential character, sort, kind, character. It is thus wider in context. The expression civil nature is wider than the expression civil proceeding. Thus, a suit is of a civil nature if the principal question therein relates to the determination of a civil right and enforcement thereof. It is not the status of the parties to the suit. It is not the status of the parties to the suit, but the subject matter of it, which determines whether or not the suit is of a civil nature. It is very important line. I should underline this. Second point, nature and scope. I must read this once again. It is thus wider in context. The expression civil nature is wider than the expression civil proceeding. Thus a suit is of a civil nature if the principal question therein relates to the determination of a civil right and enforcement thereof. It is not the status of the parties to the suit, but the subject matter of it, which determine whether or not the suit is of a civil nature. Very interesting point. Second, nature and scope. The expression suit of a civil nature will cover private rights and obligation of a citizen. Political and religious questions are not covered by that expression. A suit in which the principal question relates to caste or religion is not a suit of a civil nature. A suit in which the principal question relates to caste or religion is not a suit of civil nature. But if the principal question, in a suit is of a civil nature, the right to property or to an office, and the adjudication incidentally involves the determination relating to a caste question or to religious rites and ceremonies, it does not cease to be a suit of a civil nature, and the jurisdiction of a civil court is not barred. The court has jurisdiction to adjudicate upon those questions also in order to decide principal question which is of a civil nature. Explanation 2 has been added by the amendment Act of 1976. Before the explanation, there was a divergence of judicial opinion as to whether a suit relating to a religious office, to which no fees or emoluments were attached can be said to be a suit of civil nature. Before this explanation, there was a divergence of judicial opinion as to whether a suit relating to religious office Before this explanation, there was a divergence of judicial opinion as to whether a suit relating to a religious office. Before this explanation, there was a divergence of judicial opinion as to whether a suit relating to a religious office to which no fees or emoluments were attached can be said to be a suit of civil nature. But the legal position has now been clarified by explanation 2, which specifically provides that a suit relating to a religious office is maintainable whether or not it carries any fees or whether or not it is attached to a particular place. Before the explanation, there was a divergence of judicial opinion as to whether a suit relating to a religious office to which no fees or emoluments were attached can be said to be a suit of a civil nature, but the legal position has now been clarified by explanation 2, which specifically provides that a suit relating to a religious office is maintainable whether or not it carries any fees or whether or not it is attached to a particular place. Okay, we have completed 50 pages. I just started reading from page number 32 and just completed up till page number have already finished till page number 50. So have finished almost 18 pages, and that's fine. And tomorrow I have to start from page number 51.